કાઢી છે. તમારું બોલવાનું ને પતી જાય પછી તમારાથી ઉત્તર મુકાય ને. Hi.
Hi, good evening. How are you?
Hi. All ready?
Well, as ready as I can be, I suppose.
Hello everyone, good afternoon. We have here today Mr. Vyom Shah, a solicitor but a practicing counsel, young lawyer, now practicing in Bombay High Court. Earlier he was also practicing in the Supreme Court. He will be speaking on the Commercial Courts Act. Then he will take up the Constitution, the articles which are in the syllabus, the letters patent articles, and then he will also take up certain High Court rules as well as specific relief act. May I request all of you to please switch off your videos and audios in case they are on, so that there is no disturbance to Mr. Shah. Thank you, Mr. Shah. You can take over.
All right. Thank you. Good afternoon, everyone. Thank you to the BILS for having me here and organizing this webinar series. It's a great idea. Thank you to all of you all for attending. The idea behind this is to go through this session is to go through these acts that were mentioned. I don't think we have enough time to cover all of these acts in detail, but it would be helpful to go over some of the concepts, some of the major sections, some of the recent judgments as well, and hopefully that will be of some assistance to you. So to begin with, can we start with the Commercial Courts Act? Now, the Commercial Courts Act 2015 is a very short act, but it's really a revolutionary act because it amends the procedure of the CPC so significantly when you're speaking of trying commercial suits. Now, that makes it very important to understand what brought about this act and why was this act enacted, because the purpose is something that the courts have repeatedly resorted to interpret these sections that are in the act. The idea behind the act was in around 2014-15, there was a lot of emphasis on increasing business in India, bringing business into India. However, our commercial disputes were not being adjudicated soon enough or quick enough, which is the antithesis to what you would want when you have a commercial dispute, which is why the Commercial Courts Act was brought in. It was set up so that litigation could, or rather commercial disputes could be resolved quickly. Parties wouldn't be able to drag or delay litigation. There would not be too many appeals, etc. So matters should be viewed in that prism when we talk about the Commercial Courts Act. Now, there are three features of this act. The first feature is that the Commercial Courts Act sets up a hierarchy of courts, which did not exist earlier. On the district level, it sets up the commercial courts. On the high court level, where for courts that have original jurisdiction, which also includes our Bombay High Court, you have the commercial division of the High Court. And then you have the commercial appellate division. This code, the act was amended in 2018. While the original pecuniary jurisdiction was ₹1 crore, now you can have commercial disputes having value as low as ₹3 lakhs. So for that intervening value of between 3 lakhs to 1 crore, now you have commercial courts that have also been set up in the District and Sessions Court of Bombay. So for example, I think after the amendment of 2018, there are some 11 courts set up in City Civil Court Fort and Sessions Court, and around 5 in Dindoshi. The second feature is case management and the emphasis on case management. The act contemplates a shorter time to parties to complete pleadings, extensive procedures or rather responsibilities and duties on expediting discovery, inspection procedures. There are supposed to be hearings on case management where judges will give directions to expedite the hearing of the matters. And also, the Act specifically bars any revision on interim or interlocutory orders. We'll go through those sections. And the third feature, which is also extremely important, is that the Commercial Courts Act only provides one appeal. There are no intra-court appeals, letters patent appeals, barring those that have specifically been permitted, otherwise under this Commercial Courts Act. That's section 13 of the Act. We'll go through that as well. And then, of course, you may have your remedy to go to the Supreme Court under SLP, but that's different. So now if we begin with the Commercial Courts Act, I think the first section I would like to go to is section 2 to begin with. That is the definition section of the Act. Sorry, just a minute, please. Yes, sorry. So definition 2 defines the commercial courts, commercial appellate division, but however 2C defines commercial disputes. A commercial dispute means a dispute arising out of, those words are wide. It gives several different kinds of transactions, ordinary transactions of merchants, bankers, financiers, issues relating to admiralty, maritime law, intellectual property rights relating to registered and unregistered trademarks, copyright, patent, design, carriage of goods, agreements relating to immovable property used exclusively in trade or commerce. We'll come back to this in a minute. Contracts of insurance and reinsurance, disputes relating to contracts of agency relating to any of the above, and otherwise as may be notified. So they're broad. Of course, there are also other categories. There are two explanations. One is a commercial dispute shall not cease to be a commercial dispute merely because it also involves action for recovery of immovable property or for realization of monies out of immovable property given as security, or involves any other relief pertaining to immovable property. Which basically means that the very fact that you may seek some relief in relation to property does not mean that it's not a commercial dispute. It's not to say that a commercial dispute deals only with recovery of money. Now, a recent judgment, very recent judgment of the Supreme Court on the definition of commercial dispute that looked at this aspect of the definition which I had mentioned. Commercial dispute means a dispute arising out of agreements relating to immovable property used exclusively in trade or commerce. This is Ambalal Sarabhai Enterprises Limited versus KS Intraspace LLP, 2019 SCC Online Supreme Court 1311. Now in this matter, there was an agreement between two persons for transfer of immovable property. There was some dispute as to amounts that were to be paid. It was finally agreed to execute a mortgage, and then a party brought a suit for enforcement of that mortgage. Now, the jurisdiction was disputed by the defendant on the ground that it was not a commercial dispute because the property that the agreement related to, that was not used for trade or commerce. The property was originally used by an industry, but he still contested that. The idea was the Supreme Court was looking at whether something like this would in fact be a commercial dispute. The Supreme Court held, very interestingly, that the definition of commercial dispute should be strictly construed and not broadly. While there's an earlier decision of our Bombay High Court, Nagpur bench which said it should be broadly construed, the Supreme Court has now said it should be narrowly construed. Not all suits should be made commercial, otherwise that would clog up the system. The property that is actually used for trade or commerce and exclusively used for trade or commerce, only that would be a commercial dispute. That means it cannot be ready for use, it cannot be likely to be used, or it cannot be, or rather it cannot be in the process of being used or to be used. So this is very relevant because especially when you're talking about Bombay, there may be a lot of properties which are not really used for trade and commerce. And that is why this is something that would be quite interesting to see how it plays out as well. Another thing that the court noted is that in this case, there was also no document on record or pleading to the effect why the plaintiff called it a commercial dispute. So that's the second aspect, that while drafting a plaint in relation to something rather when you want to say that it is a commercial dispute, there must be some averments as to why you called it a commercial dispute and why it falls within the definition. The second explanation to the definition was a commercial dispute shall not cease to be a commercial dispute merely because one of the contracting parties is the state or any of its agencies or instrumentalities or a private body carrying out public functions. Now, this is very evident that you cannot say it's not a commercial dispute merely because it involves the state. There used to be a tendency that people used to resort to writ jurisdiction because it was a commercial decision taken by a state. And that's not the idea because, well, there's a long line of judgments that says the court would not readily interfere in commercial matters. And these are really matters that belong to the commercial courts and that should be within that domain. So that is why just because there is a state as the defendant, that doesn't mean that it's not a commercial dispute. Then moving on to the rest of the definitions, the word document is defined fairly widely. Specified value has been defined. The specified value was earlier 1 crore when the act was enacted in 2015, but after the 2018 amendments, it is now rupees 3 lakhs. And importantly, Section 2, subsection 2, the words and expressions used and not defined in this act, but defined in the Code of Civil Procedure and Evidence Act, shall have the meanings assigned to them in that code and act. The reason I say this is very relevant is because Section 13 speaks of appeals being permitted against judgments and orders. Now the question is, what is a judgment? What is the definition to be seen? Is it the definition of judgment under clause 15 letters patent? That's a much wider definition. We'll be coming to that when we discuss letters patent. But the Bombay High Court has held that it's actually supposed to be the definition of judgment as in the Code of Civil Procedure, and that's what the definition section says as well. Then moving on to section 3, that constitutes commercial courts. Section 4 constitutes commercial appellate courts. 5 constitutes commercial division of the High Court. So the Bombay High Court commercial division is constituted under section 4. Section 5 constitutes the commercial appellate division. Section 6 and 7 bestows jurisdiction. Section 6 bestows jurisdiction on the commercial court, and 7 bestows jurisdiction on commercial divisions of high courts. There are 2 aspects that are necessary to bestow jurisdiction. One, it needs to be a commercial dispute. However, that is not enough. It also needs to be a commercial dispute having a specified value. The specified value is now rupees 3 lakhs. And in the case of the commercial division of the Bombay High Court, it would be rupees 1 crore. There is a proviso, however, to section 7, provided that all suits and applications relating to commercial disputes stipulated by an act to lie in a court not inferior to the district court and filed or pending on the original side of the High Court shall be heard and disposed of by the commercial division of the High Court. What this proviso basically says is, however, there may be certain suits, like for example, we have intellectual property matters. Those matters are filed on the original side of the Bombay High Court, though they may not have specified value. However, those will be heard and disposed of by the commercial division of the High Court. Then there's a further proviso related to the Designs Act and the Patents Act. Section 8 speaks of a bar against revision application or petition against an interlocutory order. This section is fairly clear, notwithstanding anything contained in any other law. The Commercial Courts Act very often uses this phrase, the idea being that notwithstanding any other provision permitting revision in any other law, the Commercial Courts Act clarifies that no civil revision application or petition shall be entertained against an interlocutory order of a commercial court. The idea is also fairly clear. Earlier, you used to have people filing civil revision applications in respect of certain orders, alleging that it was passed without jurisdiction or for whatever other reason. The idea has now been to limit such sort of applications. The idea is to ensure that commercial disputes are resolved quicker, Therefore, no revision applications can be filed against an interlocutory order, be it an order on issue of jurisdiction either. If a party wishes to challenge an order such as that, the party may wait, and once the decree is passed, it may be appealed against, and that will be in accordance with Section 13 of this Act. Section 13 of this Act deals with appeals. So till the appeal is filed, or rather till there is a final decree, there can be no revision in the meanwhile. Section 9 of the Commercial Courts Act is now omitted. Section 10 is of some relevance. Section 10 relates to jurisdiction in respect of arbitration matters. Arbitration matters, again, would only include arbitration matters where the subject matter is a commercial dispute of a specified value. You may have arbitrations, you may be aware. Arbitrations could either be international commercial arbitrations or domestic arbitrations. Now, Section 10, subsection 1 says that if an arbitration is an international commercial arbitration arising in a territory where the High Court has original civil jurisdiction, which is, for example, Bombay High Court, then all applications relating to such arbitration will be filed in the Bombay High Court. Section 10, subsection 2 says if it's an arbitration other than an international commercial arbitration, so that would be a domestic arbitration. If in case of applications made in respect of domestic arbitrations, which are within the territory, again, of High Court having original jurisdiction, which is again Bombay High Court, then applications would then lie with the commercial division of the Bombay High Court. However, if it's a domestic arbitration in any other jurisdiction, which is subject to the commercial courts, that would be, for example, the commercial court outside the territorial jurisdiction of the Bombay High Court, then they would lie before that principal civil court. Now, you may be aware of the concept of court under the Arbitration Act as defined in Section 2(1)(e) of the Arbitration Act. This section does not change that definition. The court you go to under Section 10 will basically be the same court as it is under Section 2(1)(e) of the Arbitration Act. Section 11 of the Commercial Court then speaks of a bar of jurisdiction of the commercial courts and commercial divisions. And it says, notwithstanding anything contained in this act, a commercial court or a commercial division shall not entertain or decide any suit, application, or proceedings relating to any commercial dispute in respect of which the jurisdiction of the civil court is expressly or impliedly barred under any other law for the time being in force. This section would apply, there would be a bar, for example, when we're speaking of matters such as matters within the exclusive jurisdiction of RERA. Those have to go to RERA. They cannot come to the commercial court under the guise of it being a commercial dispute. Or matters under the insolvency and bankruptcy code, or matters relating to maybe transfer of shareholding, etc., which would belong to the jurisdiction of NCLT. Those matters, despite a commercial dispute also including disputes arising out of shareholders' agreements, those have to go to the NCLT under the Companies Act. They do not come to the Commercial Courts Act. So this bar takes care of that aspect. Now, Section 12 of the Commercial Courts Act determines specified value. As I had mentioned earlier, there are two aspects necessary for jurisdiction of a commercial court and for this act to apply. One is being a commercial dispute. Two, it being a dispute of a specified value, which is in the case of the district courts of Bombay, between 3 lakhs and 1 crore. And in the original jurisdiction of Bombay, 1 crore plus. This speaks of how that specified value is to be determined. So specified value is basically the value that is attached to an action or suit. Now, suits are not necessarily just for damages. They may also seek an injunction. That does not mean that it is not a commercial dispute because it does not seek money. And that's exactly why you have Section 9 applications routinely being filed in the Commercial Division Bombay High Court. It's still a commercial dispute. Section 12A says that where the relief sought in a suit or application is for recovery of money, the value is to be decided by looking at the money sought to be recovered in the suit, inclusive of interest computed up to the date of filing. In the case of market value, as per 12 subsection B, it relates to the market value of the movable property or the right therein, or as on the date of filing of the property. In the case of immovable property under 12C, you have to look at the market value of the immovable property on the date of filing of the suit. And finally, as per 12D, where the relief sought in a suit relates to any other intangible right, the market value of those rights is estimated by the plaintiff shall be taken into account for determining specified value. So this is something that has to be estimated by the plaintiff, and it's on that basis that it may cross the specified value. Now, how do we calculate the specified value in respect of arbitration matters? You may have the claimant filing a claim. You may have the respondent filing a counterclaim. Section 12, subsection 2 answers that. It says that the aggregate value of the claim and counterclaim set out in the statement of claim and the counterclaim shall be the basis for determining the specified value and whether it's to be filed within the commercial court, commercial division. And finally, it says no appeal or civil revision application under section 115 of the code may lie from any order of this commercial division or commercial court finding that it has jurisdiction to hear a dispute. Section 12A is the next section that we speak of. Now, this section was added by the 2018 amendment, and it mandates pre-institution mediation of disputes between parties. However, there is a catch. A suit which does not contemplate any urgent interim relief shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation, which basically means that if the plaintiff is of the opinion that there is sufficient urgency, then there is no requirement for mandatory pre-institution of mediation. However, if the plaintiff is of the opinion that there is no urgency, then it is mandatory for him to first approach the Legal Services Committee, and the two parties will then attempt to mediate their disputes. It is a very positive step in the whole mediation process. A lot of commercial disputes may be worked out this way, and that's great. However, practically there may be a difficulty because very often plaintiffs would run to court seeking some ad interim relief on the basis of some urgency. Questions also would remain. What happens if the honorable judge then says that there was no urgency? However, that is something we'll have to see. We'll have to see how things work out. For that matter, the time being, there are also pre-institution mediation rules that have been enacted. They are the Commercial Courts Pre-Institution Mediation and Settlement Rules 2018. These set out detailed provisions that are applicable to mediation, including the fees that are payable to mediators and the procedure that is to be followed. Mediation proceedings are to be carried on between the parties. They are to be completed within a period of 3 months. However, they may be extended for a further period of 2 months with the consent of the parties. This period will not be considered while looking at while computing limitation under the Limitation Act. And if parties do agree and settle their disputes, then a settlement will have the effect of a settlement award under Section 30 of the Arbitration Act, which basically says that an award passed on settlement has the same effect as any other arbitral award, which would then be able to be enforced as a decree under Section 36 of the Arbitration Act. Now going to the next section, and that is the section that relates to appeals. Now this section is, I'm sorry, am I audible? It says the audio has gone off.
No, you are audible. You're quite audible.
All right.
You can be a little loud if you want, but otherwise it's fine.
Okay, yes, I'll be a little loud. So Section 13 speaks of appeals from decrees of commercial courts and commercial divisions. There's been a fair amount of litigation in relation to this section in the Bombay High Court as well as in the Supreme Court. And we will discuss some of those judgments right now. But the section basically says that any person who is aggrieved by the judgment or order, prior to the 2018 amendment, they used the word decision. However, it's now been amended to judgment or order. So any person aggrieved by the judgment or order of a commercial court below the level of a district judge may appeal to the commercial appellate court, and any person aggrieved by the judgment or order of a commercial court at the level of district judge or the commercial division may appeal to the commercial appellate division. Provided, however, that an appeal shall lie from such orders only that are passed under, rather, that are specifically enumerated under Order 43 of the CPC, which speaks of orders that are appealable, or under Section 37 of the Arbitration Act. Just to clarify this, it says, notwithstanding anything contained in any other law, which is again extremely extremely broad, for the time being in force, all letters patent or of a high court, no appeal shall lie from any order or decree of a commercial division or commercial court otherwise than in accordance with the provisions of this act. This basically means that an appeal is maintainable either if it falls within the provisions of Order 43 of the Code of Civil Procedure, or in case of an arbitration matter, if it falls within the provisions of Section 37 of the Arbitration Act. You must be aware, Section 37 of the Arbitration Act deals with appeals arising out of arbitration matters covered under Part 1. However, Section 50 of the Arbitration Act before that, it also clarifies that barring those appeals, no letters patent appeals can be filed in respect of any orders or decisions passed by the commercial court. Now, there was a litigation in the Supreme Court, Arun Dev Upadhyay versus Integrated Sales Service Limited, 2016. This was 2016 9 SEC 524. It was in this matter where a judgment was passed by a single judge sitting in the original side of the High Court. And the question was, is the appeal permissible under the Arbitration Act? Because it was appealable under Section 50. But Section 50 has not been specifically clarified in the Commercial Courts Act. So the Supreme Court held that yes, because it is specifically permitted under this Arbitration Act, it was not the intention of the Commercial Courts Act to take away appeals that are permitted under the Arbitration Act, so a letters patent appeal would lie. However, in 2018, there was another Supreme Court decision, Kanla Export Corporation and another versus OCI Corporation and another, 2018, 40 SEC, 14 SEC, 715. The question over here was the opposite, that if a decision is not appealable under Section 50 of the Arbitration Act, can it then be appealed under Section 13(1)? Because it may be a judgment or an order, but there is no specific bar to appeals under Section 50, because the Commercial Courts Act Section 13 only speaks of Section 37. So at that point of time, the Supreme Court said no. It is only appeals that are permissible under the Arbitration Act, in respect to which you may file a letters patent appeal, but otherwise, all other appeals that are not appealable under the Arbitration Act or under the Code of Civil Procedure, no appeals are maintainable. The court also considered the intent of the Commercial Courts Act, which was what we discussed earlier, the idea being to expedite resolution of commercial disputes and to provide multiple appeal options would really not further the cause of the enactment. And that's why it was held that no appeal is permitted. The Bombay High Court has also passed several the Bombay High Court has also passed several orders in matters subsequent to the 2018 amendment. One may see Shailendra, Bhadoria and others versus Matrix Partners, India Investment Holdings LLC and others, 2018 SCC Online Bombay 13804. It was held that because of the 2018 amendment, which deleted the word decision and used only the words judgment and order, and also because of the Kanla Export Corporation Supreme Court judgment, which I just mentioned, it was held that appeals filed against an order passed by a single judge in execution applications filed for enforcement of an award was not maintainable under the CPC, and therefore such an appeal was not maintainable under Section 13 of the Commercial Courts Act. Now, the question was whether judgment was to be construed as judgment and having the meaning of letters patent or the meaning of the Code of Civil Procedure. It was said no, the word decision has specifically been removed and the words judgment and order have been added. Those have to be narrowly construed. The Bombay High Court has also held in another recent judgment, that is 2019 6 Bombay Case Reporter 805, Kakade Construction Company Limited versus Vistra ITCL India Limited. This was a matter in which a single judge had appointed a court receiver on properties. The order was passed in a chamber summons that were taken out during execution proceedings, and an appeal was filed. A preliminary objection was raised by the respondent on maintainability on the ground that the impugned order was not appealable, and it's only appeals under Section 37 of the Arbitration Act that are appealable. The Bombay High Court said yes, only appeals that are permitted under Section 37 of the Arbitration Act are appealable. Execution proceedings pursuant an arbitration award would be arbitration proceedings, and if it doesn't come within the narrow confines of Section 37, Section 13 has a clear bar, and therefore no appeal is maintainable. So this is another step in the same direction, and all of this is also, and rather not all, the Supreme Court hasn't noticed all of this in the next decision, but the Supreme Court has again very recently in BGS, SGS, SOMA, JV versus NHPC Limited, 2019 SCC Online, Supreme Court 1585. This is a very relevant judgment. It also speaks, or rather clarifies a lot of positions in arbitration law, but this was in relation to the appeal provisions of the Commercial Courts Act. And the question was whether an order returning a Section 34 petition, because it was filed in the wrong court, there was a question whether such an order was appealable. The Supreme Court said, no, such an order is not appealable, no appeal is maintainable. So after all of these decisions, I think Section 13 is now, well, at least it would appear to be fairly clear. The grounds for appeal are very narrow. It's a commercial dispute. You cannot keep on expecting endless rounds of appeal against orders, interlocutory orders, or using or claiming that it's appealable under the letters patent. Then let's move on to Section 14 of the Commercial Courts Act that speaks of expeditious disposal of appeals. And then finally, Section 15 of the Commercial Courts Act. Now, Section 15 of the Commercial Courts Act speaks of a transfer of pending suits. The act was enacted in 2015. At the time of enactment, Section 15 considered or contemplated that all suits that related to commercial disputes would stand transferred to the commercial divisions. Therefore, subsection 1 of Section 15 says all suits and applications under the Arbitration and Conciliation Act pertaining to a commercial dispute of a specified value pending in a high court would be transferred to the commercial division. Suits and applications relating to commercial dispute of specified value pending in a civil court would then be transferred to the commercial court that has been constituted for that jurisdiction. There was one exception, however, that when the final judgment has been reserved, so arguments have been completed, then such suit was not to be transferred. Now that stage may have passed. However, 15.4 is of some significance and relevance. So I'll just read out Section 15.4. The commercial division or commercial court, as the case may be, may hold case management hearings in respect of such transferred suit or application to prescribe new timelines or issue such further directions as may be necessary for a speedy and efficacious disposal of such suit in accordance with Order 15A of the Code of Civil Procedure, which basically means that once a suit it does stand transferred to the commercial division, then the commercial division shall issue such further directions to ensure that such suit then proceeds as a commercial suit. It follows the timelines that are indicated in the schedule to the Commercial Courts Act, and it is disposed of efficaciously in accordance with Order 15A. 15A is newly added into the CPC. It's been included in the schedule to the Commercial Courts Act. It's provisions relating to case management, which would mean provisions relating to setting timelines for how to proceed with the matter, setting out for the goals on how to expedite the resolution of the matter. We'll be coming to that shortly. The proviso is also of some relevance. Provided that the proviso to sub-rule 1 of Rule 1 of Order 5 of the CPC shall not apply to such transferred suit or application, and the court may, in its discretion, prescribe a new time period within which the written statement shall be filed. Now, you may be aware that under the Commercial Courts Act, under Order 5, Rule 1, as amended by the Commercial Courts Act, a written statement has to be filed within 30 days of the service of summons, and delay may be condoned, however, not beyond 120 days. And if it's not filed within 120 days, then the defendant's right to file a written statement stands forfeited. In fact, there have also been several decisions. I will come to those shortly. However, this proviso indicates that in case of transferred suits, this 120-day period is not mandatory. There is no fetter of the court to prescribe a new time period within which the written statement shall be filed. And while there may not be any specific fetter, I suppose it is likely that the court will not grant any time beyond what it would be normal for a commercial suit. And it may not be possible to expect a very long period. Now, the Bombay High Court had held this in, The Bombay High Court had held this in Colonial Life Insurance Company Limited versus Reliance General Insurance Company, 2019, 6, Bombay Case Reporter 130. In this case, the court had held that the mandatory timeline of 120 days is not applicable to transferred suits. Another interesting matter was One Square Investments Limited versus Capri UK Investments Limited, 2020 SCC Online, Bombay 399. In this matter, the suit had been transferred and the protonotary gave the defendants some time to file their written statement, failing which right would be forfeited. The defendants were not aware that the suit had been transferred, the right was forfeited. Ultimately, defendants moved a notice of motion and the court held several different things, but one aspect which is of particular relevance is that the protonotary cannot direct filing of the written statement because it's the commercial court that has to direct such filing of written statement. Only the court can give a fresh time for filing under section 15.3 and 15.4. Reference was also made to the Reliance General Insurance Company judgment that the 120 days mandatory timeline does not lie for such matters. Moving on to section 15, subsection 5. In the event a suit or application is not transferred in the manner specified in subsection 1, subsection 2, or subsection 3, then the Commercial Appellate Division of the High Court may, on application of parties, withdraw such suit or application from the court before which it is pending and transfer it to the Commercial Court or the Commercial Division, as the case may be. So these are very significant provisions, that deal with the transfer of pending suits. Now moving to section 16 of the Code of the Commercial Courts Act. Now section 16 is again a very short section, but it is very significant because this section amends the CPC in the way set out in the schedule for commercial disputes. So section 16 subsection 1 states, the provisions of the CPC shall, in their application to any suit in respect of a commercial dispute of a specified value, stand amended in the manner as specified in the schedule. So now I'll pause here for a minute. The question over here may also be, what happens to matters? I had mentioned this earlier, like for example, intellectual property matters that are filed in the original side of the Bombay High Court. However, they do not have a specified value. This says that it needs to be a commercial dispute and a specified value for the amendments to apply. However, those may be original side matters that may not have a specified value. So the Bombay High Court recently looked at this issue. It's a very significant judgment. Bharat Bhogilal Patel versus Lights Tooling Systems India Private Limited, 2019 SCC Online Bombay 890. The question was whether in this matter the defendant had not filed his written statement. However, if I remember correctly, the value was much lower. It was around 20,000 rupees. The question was whether in that case the mandatory timeline of 120 days would apply. And the Bombay High Court said that the language of Section 16 is clear and the amended provisions would not apply to suits that are of a lower value than specified value. So this is an interesting, this is very relevant judgment. Section 16, subsection 2 says the commercial division, commercial court shall follow the provisions of the CPC as amended by this Act. Section 16, subsection 3, where any provision of any rule of the jurisdictional high court or any amendment to the CPC by the state government is in conflict with the provisions of the CPC as amended by the Commercial Courts Act, the provisions of the CPC as amended by the Commercial Courts Act prevails. This section, this subsection rather, shows us that the intent of the enactment and of the legislature is that the Commercial Courts Act is to prevail not only over the CPC as was formally enacted, insofar as it relates to commercial disputes of a specified value, but also over jurisdictional high court rules, which would mean our Bombay High Court original site rules. In fact, that argument was also taken by the defendants in Axis Bank versus Mira Gehani, and the court negatived it on, I think, the basis of 16 subsection 3. So despite the CPC having a provision, I think it's section 129, saying that the provisions of the original High Court rules would prevail over the CPC. But as per 16.3, the provisions of the CPC as amended by the Commercial Courts Act would prevail over the original High Court rules. Then section 17 to 20 are miscellaneous sections. Section 21 speaks of the Act having overriding effect. Again, it's a very broadly worded section, save as otherwise provided. The provisions of this Act shall have effect, notwithstanding anything inconsistent therewith contained in any other law for the time being in force, or in any instrument having effect by virtue of any law for the time being in force under this Act. So, except if the Commercial Courts Act specifies that it is subject to the provisions of a certain Act, then the Commercial Courts Act would prevail. The Commercial Courts Act then also provides a schedule which amends the provisions of the CPC. I'll quickly go through some of those relevant amendments. It amends section 35 of the CPC. I think that is a very relevant amendment. The idea behind this amendment is that now costs are the general rule unless the court decides otherwise. The intent is to avoid frivolous or vexatious litigation by parties. The court may have the discretion under section 35 or new section 35 to determine whether costs are payable, the quantum of those costs, when they are to be paid. They may consider several factors such as the fees and expenses of witnesses, legal fees and expenses, and any other expenses. The court, if the court decides to make an order for payment of costs, the general rule is that the unsuccessful party will pay the costs to the successful party. However, the illustration is particularly interesting. The illustration says that a plaintiff may file a suit making several claims for breach of contract. He may succeed and he may be awarded some damages. However, If the other claims are found to be vexatious or frivolous, the court may still impose costs on the successful party for wasting the court's time. This is uh, this is this is, I would think, a very useful provision. It would definitely avoid a lot of the claims that are being made that are frivolous. But at the same time, I think it is also relevant to note that some claims, I mean, for example, when you're claiming damages, damages are to be claimed, or rather, damages are to be quantified when they're finally awarded. And those claims, it may not be possible to know with certainty, but I think it would be possible to know with certainty whether a claim is absolutely frivolous or it's not. The Bombay High Court has routinely been passing orders awarding costs to plaintiffs, like, for example, in summary suits, when the defendant has not even bothered filing a reply, or when the defendant has not been granted leave to defend, or when the defendant has no real defense and the Bombay High Court has often imposed costs. However, I would point out one case, which is Dashrath Rathod versus Foxstar Studios India Private Limited, 2018 1 Maharashtra Law Journal 474. Over here, the court imposed costs on the plaintiff, and that was because of fanciful claims by the plaintiff. The court held that the court's time is not to be taken for granted, and their time is really the scarcest resource, and that really cannot be uh, argued with, because it's just that is really the intent behind the act. Do not make any fanciful claims, do not waste the court's time, and resolution of disputes would be a lot quicker. Moving on to the amendment to Order 5, Rule 1, which was the amendment we had discussed a little earlier. That is the mandatory 120-day timeline, while the CPC still permits filing of written statement beyond the time given to file the written statement if there are sufficient cause is shown and there is a long line of judgments. The Commercial Courts Act very clearly, for the case of commercial disputes, says beyond 120 days, it's not possible to file written statement. This is also included in Order 8, Rule 1 and Order 8, Rule 10. The Supreme Court has also held so in SCG Contracts India Private Limited versus KS Shamankar Infrastructure Private Limited. That's 2019 12 SCC 210. The Bombay High Court has also held this in a very well reasoned judgment, Axis Bank Limited versus Mira Gehani, 2019 SCC Online Bombay 358. The idea being that parties cannot even, this is not a clause that can be, this is not a provision of law that can be waived, and even parties cannot consent to have written statement being taken on record after 120 days. Moving on, I would then just point out Rule 3A, which specifies that denials by defendants in written statements cannot be general. They cannot just be general denials instead of providing actual denials, and also they cannot be bald denials without any reason. Um, Order 11, that relates to disclosure, discovery, and inspection of documents, has been completely amended, and a new Order 11 has been put in. The provisions relating to disclosure and discovery are a lot more thorough for the case of commercial disputes. The idea being that a plaintiff has to bring on record and disclose all documents that he relies upon, and if he does not, consequences would follow. The same with the defendant. There are several other provisions that have been put in here. You can have a look at those. Inspection has become time bound. It has to be done within 30 days, production of documents as well. The next order that I would like to speak of is summary judgment. That's Order 13A. Now, the concept of summary judgment it's a new concept. It's different from a summary suit. The idea is that either the defendant or the plaintiff can be an applicant, and once pleadings have been completed, either if the defendant or the plaintiff is of the opinion that the other party has no real prospect of successfully defending its claim, Or otherwise, if the applicant thinks that there is no other compelling reason why the claim should not be disposed of before even recording of oral evidence, then an application may be made to the judge. There is a procedure for the application which has been set out. The judge may pass an order. The court may either give judgment on the claim, or it may give a conditional order, or it may dismiss the application, or it may dismiss part of the claim and give a judgment on part of the claim. In fact, the court at this time may even strike out pleadings if it thinks necessary. Now, the court may, while looking at an application for summary judgment, also give a conditional order. What is a conditional order? Conditional order basically means the court may impose certain conditions, such as imposing costs, asking a party to provide some sort of security, something that, and that to that extent, it's similar to a conditional leave to defend under summary suit. Order 15A provides for very detailed provisions that relate to case management hearing. Court may pass an order in relation to framing of issues, listing witnesses to be examined, fixing dates for recording of evidence, for cross-examination, fixing dates for arguments, basically setting out the entire timeline for seamlessly proceeding with the matter in a quick way. Order 18 has also been amended as well. There are some significant amendments. Parties are to provide written arguments. The oral arguments are to be time bound. Affidavits of evidence that have been prepared are to be furnished simultaneously by both parties. It's not that the plaintiff leads evidence first and then the defendant files his evidence. One very important and significant amendment is 1C. The amendment 1, addition of Rule 4.1c to Order 14, which is a party has the right to withdraw any affidavits of evidence so filed at any time prior to commencement of cross-examination without any adverse inference being drawn based on such withdrawal. This is quite relevant. And also, the court, under Order 19, the court may control evidence and redact or reject evidence that it deems it necessary. This is also similar to the settled law. So this was the Commercial Courts Act. As I said, it has changed things significantly. Now, if I can move to the Specific Relief Act, and then I will move to the Constitution. You just give me a minute, please. Oh, right. Sorry. Before moving to the Specific Relief Act, I must also mention Chapter 15 of the Bombay High Court Original Side Rules, Rules 228 to 236 that deal with commercial causes. These rules define what commercial causes are. It's a shorter definition than the commercial dispute as defined under the Commercial Courts Act. The idea is that suits that were commercial were to be transferred to the list of commercial causes, including summary suits where leave to defend was given to the defendant. And then the judge may also pass orders that he deems fit so as to expedite disposal of the commercial disputes, so in that sense, the High Court rules have always contemplated this. I got a question, will summary suits be transferred? Yes, under the High Court rules, they would be transferred. Well, now moving to the Specific Relief Act. I'm sorry, can you see me? And am I audible?
Yes, audible and can.
Because it says I'm unable to connect, so I'm wondering.
That was 1 or 2%. They have rejoined. They can hear you. There are a few questions that 1 or 2% they've asked. Which book do you recommend for Commercial Courts Act? Of course, that is now you can't say. I mean, books are many and mainly barracks.
Right.
And the other is, will summary suit under Order 37 of CPC be also transferred into commercial suits if it is of commercial nature?
Yes, it would, because the High Court Original Side rules provide that if a defendant is granted conditional leave to defend, then it would be transferred to the commercial cause of list of commercial causes, and the Bombay High Court has also been accepting summary suits as commercial suits. Again, it would depend on the nature of dispute, but I honestly have not come across any commercial suit where this dispute has really arisen about whether it is a commercial dispute or not. Otherwise, commercial disputes have always been, I mean, summary suits have always been commercial disputes. I'm sorry. Uh, Moving to the Specific Relief Act. Specific Relief Act 1963 was recently amended in 2018. The principle behind the Specific Relief Act prior to the amendment was damages are the norm, specific performance is the exception if the court thinks in its discretion. This is specific performance of contracts. Post the 2018 amendment, that position has completely changed, and specific performance has now become obligatory for the purpose of enforcement of contracts. I will just read one paragraph before we begin the act just to explain where the 2018 amendment has come from. I'm reading from the Statement of Objects and Reasons of the 2018 Act. It has been felt that the Act is not in tune with the rapid economic growth happening in our country and the expansion of infrastructure activities that are needed for the overall development of the country. In view of the above, it is proposed to do away with the wider discretion of courts to grant specific performance and to make specific performance of contract a general rule than exception subject to certain limited grounds. And I'll be showing you those limited grounds. It's in section 10. Further, it is proposed to provide for substituted performance of contracts where a contract is broken. The party who suffers would be entitled to get the contract performed by a third party. This would also include compensation and costs for substituted performance. This would be an alternate remedy at the option of the party who suffers the broken contract. So this is the idea. The idea now is specific performance of contracts is compulsory unless it is not permitted for certain very specific reasons. Section 2 is the definition clause. Section 3 speaks of, it's a savings clause, which basically says that any other right under contract would not be affected by this act other than specific relief. So a right to damages would not be affected by the contents of this act. Moving to section 5 and section 6. This comes within chapter 1, recovering possession of property. Section 5 provides for recovery of specific immovable property. It's a short section. A person who's entitled to possession of specific immovable property may recover it in the manner provided in the CPC, which basically and essentially means that a plaintiff must show that he has higher right than the defendant to possession. That may be either title to the property itself, title possession. Section 6 is of it's of great relevance, and it is used very often in our courts. Sued by person dispossessed of immovable property. If any person is dispossessed, now dispossessed is not qualified. Please remember that. Without his consent of immovable property, otherwise than in due course of law, he or any person through whom he has been in possession or any person claiming through him may by suit recover possession thereof, notwithstanding any other title that may be set up in such suit. What does this mean? This basically means that if a person is dispossessed, dispossession may be actual, may be symbolic or constructive, otherwise than in due course of law, which means that if the dispossession must have happened contrary to law, if it's happened pursuant to an order of the court, then section 6 cannot be invoked. Then either that person who is dispossessed or the person through whom he has been in possession, which would mean if I'm the landlord, my tenant can then move, or the person claiming through him, in which case the landlord may move as well. They may by suit recover possession thereof. What is also very relevant is that this section does not require you to set up a title saying that you own the property. All you need to show is that you've dispossessed otherwise than in due course of law. No, there is a limitation, however. The section provides no suit under this section shall be brought after the expiry of 6 months from the date of dispossession. and no suit under this section shall be brought against the government. No appeal shall lie from any order or decree passed in any suit under this section as per subsection 3 of section 6. And importantly, subsection 4 says nothing in this section shall bar any person from suing to establish his title to such property and recover possession. Now, if you're suing to establish your title and recover possession, you can still do that despite section 6. But that you would have to do under section 5. There is one recent judgment of the Bombay High Court in relation to section 6. The question there was, this is Janardhan Narsingh Mahajan versus Makhija Bohra Builders, 2020 SCC online, Bombay 38. The question over here was whether a partnership firm can file an action under section 6. Is it a person as used under section 6? It was held that a partnership firm is not a person. It has no legal personality to the firm apart from an interpersonal relationship between the partners. And reference was also made to Order 30, which requires that all partners have to be impleaded. In this matter, partners were not impleaded. So it was held that a partnership firm by itself cannot file a section 6 suit in its own name. Section 7 and 8 deal with recovery of specific movable property. And then moving to section 9, which is chapter 2, specific performance of contracts. Section 9 basically says that as a defendant, all defenses that you may have available to you in contract law are available as defenses in a suit related to specific performance. So if A files a suit for specific performance, B can contest it on the basis of there possibly not being a valid contract, some dispute on the time for performance, some dispute on the method for performance or the mode of performance. Then section 10. Now section 10 was amended by the 2018 Amendment Act, and it's very relevant. This is very significant. This is what turns it all around. The specific performance of a contract shall be enforced by the court subject to the provisions contained in section 11(2), section 14 and section 16. Those are the only three bars. Unless you fall within the bars of section 11 subsection 2, section 14 or section 16, the contract must be performed. Now what is section 11(2)? Section 11(2) basically talks about a contract that is made by a trustee in excess of his powers or in breach of the trust. Such a contract is not capable of specific performance and cannot be specifically enforced. Section 14 speaks of contracts that are not specifically enforceable. Now, prior to the amendment, section 14 spoke of contracts, rather section 14 specified that a contract for non-performance of which compensation was an adequate relief, such a contract was not capable of specific performance, which basically means if damages would have been enough, then specific performance could not be granted. However, that ground has been taken out. So now the following contracts cannot be specifically enforced. A contract to which the person, the plaintiff, who is not the party in breach, but the party who has suffered the breach, has obtained substituted performance of the contract through a third party. For example, a contract between A and B, B is in breach, A then gets C to perform the contract instead of B. That substituted performance under section 20, such a contract cannot be specifically performed between A and B. A contract, the performance of which involves the performance of a continuous duty which the court cannot supervise. Now, what is the performance of a continuous duty which the court cannot supervise? For example, an agreement to maybe construct certain houses of a scheme and then to allot them to certain persons. Now, this is a continuous exercise, and this is not something that the court can really supervise. So such sort of contracts cannot be specifically performed. A contract which is so dependent on personal qualifications of parties that the contract cannot enforce specific performance of its material terms. Now, this is important. It's not just personal qualifications that would bar specific performance. It's a contract which is so dependent on personal qualifications that the court cannot enforce it. So, for example, while some may say employer-employee relationships may be permitted. So, some may say, yes, if the employment is contingent on very personal qualifications, that is not capable of specific performance. However, there are some exceptions. An employee of the union has been held, that employment has been held to be capable of specific performance. An employee workman who maybe goes under the Industrial Disputes Act to challenge his termination and seeks reinstatement is then enforcing his contract of employment. So those would not come under the bar of specific performance. But however, like for example, a contract with a painter asking him to make a painting and the painter having breached that, that may not be capable of specific performance, or a contract with a singer to sing uh, at a event may not be capable of specific performance. And finally, the fourth exception to contracts which are not capable of specific performance is a contract which is in its nature determinable. Now, what does which is in its nature determinable mean? This basically means a contract that can be determined by either party without any reason. Bear in mind, if a party to a contract has the right to terminate a contract because of another party's breach, that may not be in its nature determinable. That may not come under the bar. What is it needs to be a contract in which either party can unilaterally repudiate it or terminate it if they require. Section 14(1)(d), this provision has been interpreted by the Bombay High Court recently in Narendra Hirawat and Company versus Sholay Media Entertainment Private Limited, 2020, SCC Online, Bombay 391. Then the next bar, we saw section 11(2), we saw section 14. The next bar to specific relief are the personal bars to relief that are set out in section 16 of the Specific Relief Act. Section 16 sets out 3 bars. Section 16 says the specific performance of a contract cannot be enforced in favor of a person, again, who has obtained substituted performance of a contract under section 20, which we discussed. B, who has become incapable of performing or violates any essential term of the contract, which basically means that a plaintiff who's in breach of a contract cannot then seek specific performance. And C, a person who fails to prove that he has performed or has always been ready and willing to perform the essential terms of the contract, which are to be performed by him, other than the terms the performance of which has been prevented or waived by the defendant. I'll read the explanation also. For the purposes of clause C, where a contract involves the payment of money, it is not essential for the plaintiff to actually tender the amount or deposit it in court. And explanation, and 2, the plaintiff must prove performance of readiness and willingness to perform. Now, 16C basically speaks of readiness and willingness. This concept has always been around. However, the difference is that earlier there was a requirement to plead and to prove specific performance. The requirement now is only to prove specific performance. However, it would also be very prudent to plead specific performance, because to plead readiness and willingness. Because what is readiness and willingness? Readiness means a person is capable of performing the contract, and willingness means that the person is inclined to perform the contract. Readiness would also include financial capacity, financial capability. There have been several judgments passed by the High Court, Supreme Court on readiness and willingness. Some recent judgments that have spoken of what readiness and willingness is, and also financial capacity, are C.S. Venkatesh versus A.S.C. Murthy, 2020, SCC Online, Supreme Court 143. Over here, the Supreme Court has reiterated the principles of financial capacity to ascertain whether a plaintiff was ready and willing in the facts of that case. The court reiterated that the court will basically look at all facts, all attending circumstances. The court would not just look at one aspect. Again, if you have a look at explanation A, it is not necessary for the plaintiff to deposit money in court to show that the plaintiff is ready and willing. It would, however, be enough for the plaintiff to show that he has means to generate that consideration amount. If the plaintiff doesn't show that, then the plaintiff has not shown financial capacity to perform the contract. Another recent Bombay High Court judgment which considers readiness and willingness is I'm sorry, Sushila, Vijay Kumar, Paul, and others versus Nirmala, 2019 SCC Online, Bombay 5304. And well, there's another Supreme Court judgment, Ravi Sethia versus Madan Lal and others, 2019 9 SCC 381. I don't have to discuss all of those judgments. Suffice it to say that the relief of readiness and willingness is essentially a finding of fact, and it's for the court to decide whether the parties are ready and willing, and for that, all of this must be pleaded, and all of this must finally be shown to the court so that the court can take note of all attendant circumstances. What was the agreement? When was it to be performed? How was it to be performed? Was there any delay? Delay may not necessarily mean that you're out of limitation, but delay may show that you were not ready and willing to perform the contract. And finally, arrive at some decision. So that is section 16. So essentially, unless you are not ready and willing, or unless you are not capable of being granted specific performance because you yourself, or rather the plaintiff himself, is in breach, or unless the contract is such that cannot be specifically performed under section 14, or unless it is not capable of specific performance under section 11.2, a contract has to be specifically performed. Now moving to section 12. Section 12 basically speaks of specific performance when only a part of the contract can be performed. Now, for example, this may arise in situations like when a developer contracts with an owner of property to provide the property for development. There are some encroachments. Those encroachments need to be cleared. They may not be cleared. Is such a contract then capable of specific performance? Section 12 deals with specific performance in such cases. If only a part of the contract cannot be performed, but that part can be compensated in terms of money, the court may order specific performance of the contract, and to that extent award the plaintiff some compensation in terms of money. However, if the performance is such that cannot be, or rather if the contract is such that to which a significant amount cannot be performed, or if the part that cannot be performed cannot even be compensated in terms of money, what happens then? Well, in such cases, the plaintiff is not really entitled to specific performance. However, he may then still apply to the court if he is able to satisfy that the amount that will be specifically performed, the consideration will be paid by the plaintiff proportionately, or otherwise the plaintiff will have to relinquish his rights to claim specific performance of the entire contract. So the part that can be that cannot be performed under law, the plaintiff will have to relinquish rights in that respect. And finally, if there are two separate obligations, those are divisible, one is capable of specific performance and the other is not, then the court may order that one obligation be specifically performed and compensation be paid for the other. Section 13 and 17, I don't need to get into too much detail, but 13 basically speaks of rights of purchasers and lessees when the purchaser or the lessor has imperfect title. And 17 speaks of, that is, those are the remedies that a purchaser or a lessee has. And section 17 speaks of when the purchaser or the lessor may enter into a contract knowing that he has no title, in which case he would not have the authority to seek for specific performance. Specific performance of such contracts cannot be granted. Well, we've seen 13, we've seen 14. Now, if we can have a look at section 15. 15 of the Specific Relief Act, it's a fairly simple section. It speaks of all persons who may obtain specific performance. Specific performance of a contract may be obtained by any party or his representative. However, there are two exceptions. One, if the representative, or rather if assignment is not permitted as per the contract, then the representative would not be in a position to seek specific performance. This is in accordance with basic contractual provision, the contractual principle that liabilities of a contract cannot be assigned to another party without the rather liabilities cannot be assigned to a third party without the other party being aware and being agreeable to such assignment. So if the other party to a contract is not aware that the contract has been assigned, then the representative cannot seek specific assignment. Again, when the contract is such that it depends on personal qualities, then the contract cannot be assigned, and in such case, the representative cannot seek specific performance of the assigned contract. The Supreme Court has recently looked at specific performance of an assigned contract and whether an assignee can seek specific performance in Kapila Bain and others versus Ashok Kumar Jayantilal Sheth, 2019, SCC Online, Supreme Court 1512. This judgment discusses this issue in some detail. If you are interested to have a look. The rest of the section speaks of various different situations where parties may obtain specific performance. Section 18 speaks of non-enforcement of a written contract except with variation. The principle is fairly simple that a written agreement cannot be performed as per its terms when it is established that it is varied by the parties, or if it does not contain the terms that have been agreed by the parties. Therefore, if the objective of the parties is different from what is written in the written agreement, then that written agreement is incapable of specific performance. Section 19 speaks of relief against, we don't need to get into section 19. Section 20 speaks of substituted performance of contract. We've already discussed this at length. Section 20A provides specific provisions for contract relating to infrastructure projects. Now this is very relevant. This basically, Section 20A says that no injunction shall be granted by any court in respect of any infrastructure project that is provided in the schedule. This is an addition by the 2018 Amendment Act. The idea being that infrastructure projects should not be held up on account of injunctions granted in specific performance suits, and therefore they should not be delayed. So therefore, no injunction shall lie in respect of infrastructure projects. 20B provides for special courts for infrastructure projects, and 20C speaks of expeditious disposal of suits. Section 21 provides a power to the court to award compensation in certain cases. Now, this section has also undergone some change with the 2018 Amendment Act. You will recollect earlier the case was that if the breach is capable of being remedied by damages, then no specific performance would lie. However, now it has been clarified that in a suit for specific performance of a contract, the plaintiff may also claim compensation for breach in addition to performance. So now both are available. However, such breach, deciding such breach, the court would ultimately have to go to the principles of Section 73. The court would then see whether loss has been caused, and if such loss has been caused, then the court may order specific performance, but may also order breach and some compensation, like for example, maybe in the case of delay. So this provision has been amended to now permit compensation in addition with specific performance. Moving on to section 23, which specifies that liquidation of damages is not a bar to specific performance. The very fact that damages may be liquidated and provided in a contract does not mean that specific performance is not permissible. This section has always been around. And moving now on to the next kind of specific relief that is provided in the Specific Relief Act, that is rectification of instruments. Section 26 speaks of instruments that may be rectified when they've been entered, but due to fraud or mutual mistake, the contract or agreement in writing does not speak or does not necessarily say what the parties wish it to be say. So if a party seeks rectification, the party may move court for that purpose. And section 26 subsection 3 is of some relevance. because what happens very often is a party may move the court and say that yes, this contract does not speak what I wish it to speak or what it should speak. So it may seek rectification from the court, and then the party may also speak specific performance of such specific enforcement or specific performance of such rectified contract. So first the court may rectify it and then may order specific performance. The next chapter is chapter 4, rescission of contracts. Certain contracts may be rescinded by the court if the contract is voidable or terminable by the plaintiff, or if the contract is unlawful for causes that are not apparent on the face and the defendant is more to blame than the plaintiff. These situations, whether the contract is voidable, terminable, all of these are aspects that would really come in within contract law, and the court, if satisfied, may rescind the contract. Section 28 provides for rescission of contracts after a plaintiff has been awarded a decree. So if a decree holder does not carry out his obligations, for example, does not within the period permitted by the decree pay the purchase money or such other sum as the court may direct to uh, execute the agreement, then in that case, the court may have the contract rescinded, which means the decree holder can, in that case, not apply for the property as per the decree. As per the decree, that contract stands rescinded. Moving on, Section 30 says the court may require parties rescinding to do equity, which is fairly obvious. On a judging the rescission of a contract may require the party to whom such relief is granted to restore so far as may be any benefit which he may have received from the other party. Restoration is a sound principle in law and in equity, and also found in Section 30 of the Specific Relief Act. I don't know how much more time we have, so I think I'll speed this up a little. Chapter 5 deals with cancellation of instruments. Chapter 6 speaks of declaratory decrees. Section 34 is of some relevance. It gives discretion to the court to declare any status or right. So if a plaintiff approaches the court seeking declaration of a legal character or a right to any property, then the plaintiff may suit or may institute a suit seeking such declaration of status or right. The court may, in that case, give such declaration. However, there is a proviso which is extremely important. No court shall make any such declaration where the plaintiff, being able to seek for further relief than a mere declaration, omits to do so. What does this proviso mean? This basically means that as a plaintiff, A may seek declaration, A says A is the owner of the property, or B says, and he says B is in possession of the property. A may seek a declaration that he is owner of the property. But if he does not also seek possession of the property that B is now in possession of, then that declaratory decree by itself cannot be passed. Why is this the case? Because such a decree would simply be unexecutable. The idea being that you first seek declaration and then the next obvious thing, which is you seek possession of the property. Let's take another example. For example, an employee whose employment is terminated, he may seek a declaration that his termination was illegal. But if he doesn't seek reinstatement, then that doesn't take him anywhere, which is when the proviso comes in, and such a declaration without further follow-up relief will not be granted by the court. The next section is 35, which speaks of the effect of such declarations. A declaration made under this chapter is binding only on the parties to the suit. It's not an order in rem, it is really an order in personam, and it only binds the parties to the suit. Then chapter 7 speaks of injunctions. We come across injunctions day in and day out. Section 37 speaks of what temporal and perpetual injunctions are. Temporary and perpetual. Temporary injunctions are injunctions granted under Order 39 of the Code of Civil Procedure. Perpetual injunctions can only be granted by decree made at the hearing and only after hearing the merits of the suit. And thereafter, with a perpetual injunction, a defendant is perpetually enjoined from the assertion of any right or from the commission of any act which would be contrary to the rights of the plaintiff. Section 38 speaks of when a perpetual injunction can be granted. Now, injunctions under the specific relief act are granted when obligations are breached or threatened to be breached. Not so, for example, a specific performance of a contract can be granted when the contract is breached. When obligations are breached, and obligations defined in the Specific Relief Act, the court may grant injunctions. So Section 38 says a perpetual injunction may be granted to the plaintiff to prevent the breach of an obligation existing in his favor, whether expressly or by implication. And such an injunction can be granted when the defendant invades or threatens to invade. So it may also be anticipatory, the plaintiff's right to or enjoyment of property. Section 39 that provides for mandatory injunctions. What are mandatory injunctions? They are simply injunctions that are necessary to compel the defendant to perform a certain act. The court may, in its discretion, grant such injunctions. While granting mandatory injunctions, those are typically not granted very often. The idea is, and there are a lot of judgments, there is a recent judgment of the Supreme Court that is, just get the name, Samir Narayan Bhojwani versus Aurora Properties and Investments, 2018 SCC Online Supreme Court 1048. This clarifies the law on passing of mandatory injunctions, and it says mandatory injunctions should not commonly be granted at the interim stage unless it is being granted to preserve or restore the status quo of the last non-contested status. So it is only to bring the parties back to what the status quo was that mandatory injunctions should commonly be granted at an interlocutory stage. Thereafter, Section 40 speaks of damages that may be granted in lieu of or in addition to injunctions. Section 41 speaks or provides certain circumstances or instances when injunctions may be refused. And Section 42 finally speaks of injunctions to perform negative agreements. I think this would also take care of the Specific Relief Act. Now, to move on to the next section, which is going to be discussed, let's have a look at the articles of the Constitution. There are only some articles, I believe, that are in the syllabus, beginning with Article 32. Just give me a minute, please. Yes. So Article 32 of the Constitution of India provides a right to every citizen to move the Supreme Court for enforcement of rights conferred by this part, which is Part 3. Now, Part 3 speaks of fundamental rights and also other rights. Part 3 is from Section 12 to Section 35. This speaks of such as right to equality, right to freedom of speech, right to life, also other such rights as cultural and educational rights, right against exploitation, right to freedom of religion. The Supreme Court's powers under Article 32 are extremely wide. It has the power to issue directions, it has the power to issue orders, and it has the power to issue writs. Writs would be writs in the nature of habeas corpus, mandamus, prohibition, certiorari, and quo warranto, whatever this court may deem appropriate. We'll discuss these writs in a little more detail when looking at Article 226, which is the provision related to writs by our Bombay High Court. Moving on to the next article, which is Article 133. Yes. Now, Article 133 provides appellate jurisdiction to the Supreme Court in appeals from High Court in regard to civil matters. Now, for an appeal under Article 133, it is necessary that the High Court certifies that this is a case fit for appeal. Now, I remember some old judgments. If you have a look, you see some of them saying that this is appealed under Article 133. There are two aspects that would be relevant. One is the case needs to involve a substantial question of law of general importance. So, not just anything. And two, that in the opinion of the High Court, the question needs to be decided by the Supreme Court. So I would think this would probably, substantial question of law of general importance would also probably include something that would have national repercussions, that would maybe something that is being looked at by various courts in the country. Then Article 134 speaks of appellate jurisdiction of the Supreme Court in regard to criminal jurisdiction, or criminal matters rather, sorry. Says an appeal shall lie to the Supreme Court from any judgment, final order, or sentence in a criminal proceeding of a High Court in the territory of India if the High Court has either on appeal reversed an order of acquittal of an accused person and sentenced him to death. So the accused was acquitted, but the High Court on appeal has now sentenced him to death. Two, the High Court has withdrawn for trial before itself any case from any court subordinate to its authority, and in such trial convicted the accused and sentenced him to death. So, for example, the proceedings been pending in a lower court, High Court transfers it to itself and sentences the accused to death. Or if the High Court may certify under Article 134A that the case is a fit one for appeal to the Supreme Court. Article 134A then provides when such certificate may be given. Every High Court may grant a certificate for appeal under 133 or 134 on its own motion, or if an oral application is made by or on its behalf, by or on behalf of the person who is aggrieved by such a decision. Moving on to Article 136. Now, 136 is not really an appellate provision such as a statutory appeal. It's not a right to appeal. It is a special leave to be granted appeal. It's a discretionary power of the Supreme Court. It's a very wide power. So, notwithstanding anything in the chapter, a party may approach the Supreme Court against any decision, past or judgment or order or sentence or determination passed in any cause or matter. Now, these are extremely wide terms. That is made by any court or tribunal in the territory of India. What the party does, it applies to the court by way of an SLP. It seeks leave of the court. The court may issue notice if the court is of the opinion that leave to appeal may be granted. And it is only when leave is granted that the SLP stands converted to an appeal. So very often, the SLP may just be dismissed even before being converted into an appeal. So the SLP is a discretionary power of the Supreme Court. It's extremely wide and it can be invoked by the Supreme Court in respect of any decision or order. There is a lot, of course, to be said in respect of Article 136, but I don't think we can get into all of that right now. Article 141, that is a short article. It clarifies that the law declared by the Supreme Court shall be binding on all courts within the territory of India. The law declared by the Supreme Court would evidently be couched in precedents and its judgments, and which essentially this is where the doctrine of following the law of the higher courts comes from. And it is incumbent for all courts to follow the decisions and the propositions of law that are settled by the Supreme Court. Now, if we can move on to Article 226 and 227 of the Constitution. Now, Article 226 is the power of the High Court to issue writs. It says, notwithstanding anything in Article 32. So it is unaffected from it is unaffected by the power of the Supreme Court to under Article 32. Every High Court under 226 has the powers throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority within this jurisdiction writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or for the enforcement of any of the rights conferred in Part 3. Now, the rights in Part 3 are fundamental rights that we discussed rights against exploitation, cultural and scientific rights, right to freedom of religion. So the High Court can also issue writs in respect of any and all of these rights to persons approaching them against authorities in their territorial jurisdiction. 226 and 227 both. Their extraordinary jurisdiction of the court. It's largely discretionary. There are no limitations really on the court's power to issue writs. However, it is a settled provision that such discretion must be exercised as recognized lines and it need not be arbitrary. And ultimately, the idea is to do substantive justice. In fact, that is what it's called. There is a doctrine of substantive justice where the courts will not exercise this discretion unless substantive injustice has ensued or is likely to be ensued. Now, what are these writs? I will very briefly, I suppose you may already know what the writs are, but just one line on what these writs are. Habeas corpus is issued as a writ to produce a person before a court when that person has been detained or imprisoned. Mandamus is an order to a authority that is required to do a public duty, to act legally, and to abstain from perpetrating what is considered an unlawful act. So when such government or public authority has to perform a statutory duty, but it fails to do so, then a party may approach the court and then seek a writ of mandamus. What is prohibition? A writ of prohibition is essentially a writ by the High Court prohibiting the lower court from acting or from violating the powers that are vested in it, or from prohibiting it from continuing proceedings, which according to it, it is not really carrying on properly to the extent that it is not discharging its judicial functions and it's carrying out arbitrary actions. A writ of certiorari is slightly similar, but it's not the same. It's actually different. It is a writ issued by the High Court on the ground of a lower court acting on lack of jurisdiction. It could be either lack of jurisdiction, it could either be excess of jurisdiction, or it could even be an abuse of jurisdiction. It could be violation of principles of natural justice, or maybe even an error of law that's apparent on the record. So all of those grounds would then be suffice for a writ of certiorari. And quo warranto is essentially a writ to restrain a person from holding a public office when that person is not entitled to such public office. Can there be any fetters on such writs or such powers, discretionary powers of the court? No, there are really no fetters per se. However, our High Court and the courts generally, including the Supreme Court, has evolved certain self-imposed restrictions really, and they're quite well recognized. Some of them may be that an alternative appellate remedy may be available to the parties, maybe delay. There may be, well, if the conduct of the petitioner itself is not right. So let's look at some of those limitations. The first one is a writ may not be granted if there is an alternative remedy available. The Supreme Court was looking at this issue recently in Embassy Property Developments Private Limited versus State of Karnataka, 2019 SCC Online Supreme Court 1542. Over here, the Supreme Court was looking at two questions. One was whether High Court can interfere under Article 226, 227 against an order of the NCLT, despite there being an appeal provision to the NCLAT, and two, whether the NCLT can look at questions of fraud. Now, the second question is not relevant for us. However, in the first question, the Supreme Court first looked at the nature of the power of the High Court under 226. Nature is obviously the extent of power is wide, and it's also constitutional. When confronted with a petition under 226, the court has to see the distinction between lack of jurisdiction and wrongful exercise of available jurisdiction. So if there's a complete lack of jurisdiction, then you may still be able to go under 227. But if there's wrongful exercise of available jurisdiction, then it may be better to go by appeal. What is relevant also to see is whether the action that is being opposed, whether that falls in the realm of public law or private law. If it's public law, then that may, this was in the context of insolvency proceedings, and whether an order passed by the NCLT in insolvency proceedings can be upset under 226, 227. The court said an order under public law to maybe even upset a judicial decision of some other tribunal, which may have some kind of effect on the insolvency process. Now, that cannot be something that is subject to the jurisdiction of the NCLT. If another tribunal passes an order which affects the insolvency proceedings, then if that needs to be challenged, that is something that could possibly be challenged under 226 and 227. The RP cannot short circuit all of those provisions and in fact challenge judicial, quasi-judicial proceedings and decisions before the NCLT. That is not permitted. So what really has to be seen is what needs to be challenged and what the wrong that is complained of is. So in this case, it was held that despite there being an appellate authority, the writ jurisdiction may be available. Now, second self-imposed restriction often that is often placed in matters relating to writ is for commercial matters, writ courts generally don't really interfere. There's a long line of judgments. The most recent or amongst the most recent is SILPI, SILPPI, Constructions Contractors versus UOI. This is 2019 SCC Online Supreme Court 1133. The judgment sets out a lot of the decisions that speak of when courts would interfere in commercial matters. The idea being that courts would generally not interfere in commercial matters where PSUs and government authorities are involved, because ultimately those entities also have to compete with private entities, and there's no reason that the courts would only involve themselves not in respect of the decision, but if the decision making process is malified, or unless there's some substantial public interest involved, or unless there is a clear-cut case of arbitrariness or bias or irrationality. It is only in those cases that the court would involve themselves in commercial matters. Another restriction to writ jurisdiction would be the court would not involve itself in matters of fact. Matters of fact where both parties are not agreeable on certain factual elements, those would best be decided in a suit where parties lead evidence and the court finally decides. Writ proceedings are not proceedings. Writ proceedings would also, the Supreme Court has recently held this has been held by the Supreme Court in Sanjay Kumar Jha versus Prakash Chandra Chaudhary, 2019 to SCC 499. The court would very rarely upset a finding or an order on the basis of a factual error. It would either return the matter to the lower court, but only if there is significant delay or if there's any particular factual error which is fairly obvious, would the court rectify that in writ. Another limitation would be delay in laches. So, for example, a petitioner who has not approached the writ court in time the court may also refuse to exercise its jurisdiction, its discretion under Article 226 to 27. The recent judgment of the Supreme Court on delay and laches in writ is in University of Delhi versus Union of India, 2019 SCC Online Supreme Court 1634. And finally, honestly, it may also be discretion may also be refused if a petitioner has not come to court with clean hands, or if his conduct is not such that is deserving of the court's discretion. I think in respect of 226 we're really done, except there's one recent judgment of Maharashtra Chess Association versus Union of India. It's an interesting judgment. This is 2019 SEC Online Supreme Court 1634. This looks at whether writ jurisdiction is ousted when parties in an agreement may agree that one particular court has certain jurisdiction. So as per section 16 to 20 of the CPC, you must be aware of this. Several courts may have jurisdiction. Parties may agree that only one court out of those has jurisdiction. But what happens if a party wants to move a writ in another court? And the Supreme Court held that in such cases, a party may move a writ in another court if that court exercising its writ jurisdiction, which is a constitutional provision, may be of the opinion that its discretion is to be used in the facts and circumstances of the case. So there is really no bar, even though the parties may have agreed that they will go to a particular court. Now, Article 227 is the last provision of the article. Article 227 gives courts the power of superintendence not only over all subordinate courts in their territory, but also all tribunals throughout their territories. The idea is that such bodies must be discharging some judicial or quasi-judicial function. This power is wide and discretionary, and it is used again to meet the ends of justice. So in that sense, the High Court can look at equitable solutions. And in fact, that's also the case in 226. However, I must also say this, that this power is to be used very sparingly. It is not used to correct mere errors of law or mere errors of fact. However, if it is an error of jurisdiction that goes to the very root of the matter, or if it's some such error, then it is capable of being challenged under Article 227. The Supreme Court recently in Deep Industries Limited versus ONGC, now I don't have the SCC version, but 2019-17 scale 85, this is a scale citation. It has recently considered whether an Article 227 petition can be filed against orders passed under the Arbitration Act. The Supreme Court has held in this that there is no bar because it's a constitutional provision, so it cannot be prohibited. However, at the end of the day, it is a power which is to be very sparingly used. And given that the idea behind the Arbitration Act is minimal judicial interference, it is the courts must be very circumspect in then trying to permitting resort to Article 227. And in fact, the court went one step further and said you must also look at the law relating to revision, and that is revision under section 115, and no revision lies if there is an alternative remedy. And even when revision lies, it lies only against the final disposal of the matter and not against an interlocutory order. So then what can really be done under Article 227? It can be exercised maybe due to grave failure of justice when a court assumes jurisdiction that it does not have, maybe when it fails to exercise jurisdiction which it has, or when the jurisdiction is, though available, is being exercised in a manner which oversteps the limits of its jurisdiction. So it needs to go inherently to its jurisdiction for such sort of for relief under Article 227. I think that is really it. The difference between Article 226 and 227 is 226 is mostly concerned with the power to issue 5 writs. 227 is concerned with superintendence over courts and tribunals within the country. And I think that's about it. Yes, and I think one other aspect that should be pointed out is the difference between, while the Supreme Court recently in ONGC versus Deep Industries has pointed out that reference should be made to revision, I think reference must also be made to the Bombay High Court judgments which distinguish between Article 227 and 115. Justice Malapale, I think, has passed a couple of judgments. One is Dhondiba Naik versus Sriram and Dalkar, I think. 2000. I'm sorry, I don't know if I was audible. I was reading that. Dhondiba Naik versus Sriram and Dalwar, 2003, 6, Bombay Case Reporter 844. Very often, and also another one that relates to the Rent Act, 2003, SCC Online, Bombay 1166. So very often you have persons filing 227 against interlocutory orders, and final orders are and filing revisions against final orders. I think we're done with almost all of this. I know it's been a long session, but there's just been a lot to say. I think
you have finally to do letters patent. Article.
Yes, I was just coming to that. Letters patent, clause 12 and clause 15. Clause 12 of letters patent speaks of original jurisdiction as to suits. So clause 12 of the letters patent of Bombay High Court provides that Bombay High Court shall have original jurisdiction in three matters. One is in the case of suits, which are suits for land and have arisen within the territorial jurisdiction of the court. Two is if the cause of action has arisen partly in Bombay High Court, partly within the territorial jurisdiction, but leave is obtained. And three, if the defendant at the time of commencement of the suit dwells or carries on business within the limits of the territorial jurisdiction. However, it has been clarified that this would not include matters in which jurisdiction is with the small causes court and the city civil court. Now, two aspects over here. One is if it's a suit for land, it has to be within the jurisdiction of the territorial high court. What exactly is a suit for land? The Bombay High Court has also looked at that. Not all suits which incidentally may seek certain reliefs in respect of property will be suits for land. For that matter, the Bombay High Court, let me open my notes. Right. The Bombay High Court has held in Shah Distribution House Private Limited. Sorry, no, not that. It has held in Vinod Grover versus Videocom in Realty and Infrastructure, 2018 SCC Online Bombay 3908. That if it's a suit for specific performance with prayer for delivery of possession, that is not a suit for land always. It ultimately depends on what the prayers are and what the suit is. If it may be a suit for specific performance of the contract and not necessarily for prayer of possession. If the prayer of possession is incidental, then it's not really a suit for land, in which case then if it is a suit for land and if it's outside territory, then you cannot come in seeking leave under clause 12. Then the leave has to be revoked. However, if it is not a suit for land, then you may take leave under clause 12, and then in that sense Bombay High Court would have jurisdiction. So there are some judgments on what is a suit for land, and this is one of them. The second aspect is when does clause 12 have to be obtained? Leave under clause 12 has to be obtained prior to lodging of the suit. There are, or rather prior to the suit receiving it, there are some relevant judgments. I won't go through all of them, but one is Caribjet Inc. versus Air India Limited. This is a 2005 judgment, 2005 to Maharashtra Law Journal 461. And very interestingly, there is a recent Supreme Court judgment, 2019 for Scale 474, which speaks of Isha Distribution House Private Limited versus Aditya Birla Nuvo Limited. This came from a decision of the Calcutta High Court. And the question was whether an application could be filed for revocation of leave under clause 12. And the Supreme Court held in the facts of that matter that the plea of territorial jurisdiction was a mixed question of law and fact. So the defendant should actually file a written statement and then follow the provisions of the CPC, and cannot simply file an application for revocation of law. So, of course, in the facts of that case, the plea of territorial jurisdiction was found to be a mixed question of law and fact. So that is something that must be taken into consideration. Moving on to clause 15 of the letters patent. Clause 15 of the letters patent provides for appeals. Clause 15 basically says an appeal may be filed by a judgment passed by single judge of the High Court. However, there are certain exceptions. One, it cannot be passed. It cannot lie for judgments that have been passed in appellate jurisdiction. Two, it cannot lie against orders that are passed in revisional jurisdiction. Three, it cannot lie against orders passed in petitions filed under Article 227. And four, it cannot lie against sentences or orders passed in exercise of criminal jurisdiction. Other than that, however, letters patent provides that a letters patent appeal can be passed against a judgment of the court. Now the question is, what really is a judgment and how is this term to be interpreted? there is a very authoritative judgment. It's a very old judgment of the Supreme Court. It is Shah Babulal Khimji versus Jayaben D. Kanya, 1981 for SCC 8. It basically, the crux of the judgment is basically this, that if a judgment decides the rights of the parties in any manner, and the judgment or rather the term judgment is construed widely, then such judgment would be a judgment within the intent of clause 15, and then those would be appealable. This is not, and this should in fact be noted, that this is very different from the definition of judgment under the Commercial Disputes Act, which is a narrow definition. But however, for the purposes of letters patent, it's a wider definition, and this judgment is quite instructive in this matter. I think we're largely done. I think I just have a few provisions of the High Court rules to go over. Yes. Right. So the High Court rules that I'm looking at are, well, a few chapters, not all of them, so not too much longer. One is Chapter 8, which is third-party procedure. That's rules 107 to 120. This essentially provides that that a defendant to a suit may make claims against another party who's not a party to a suit relating to the subject matter, or the defendant may also claim some contribution or indemnity from such other person. And in such case, the defendant may apply to the court for issue of a third-party notice and make that person a party to the suit. Once that person is a party to the suit and has been served, then that person must attend. And if he does not, he is bound by all the orders and decrees passed in the suit. And this can go on. So that third party can also then implead another person if he thinks necessary by virtue of a fresh third-party notice. Chapter 11 of the High Court original side rules, that are rules 150 to 189A, deal with matters that arise pending the suit. These are matters that we face very often on a regular basis. Miscellaneous rules that relate to various stages of the suit, which include amendments to pleadings, discovery of documents, inspection, maybe even changes to advocates during the suit. It also deals with when and how applications should be made in interlocutory applications. These rules also provide for recording of evidence and appointment of commissioners. Then Chapter 12 of the High Court original side rules, that are rules 190 to 209, they are rules that deal with the process for swearing of affidavits inside and outside of court, or maybe even outside of India. They provide the formal requirements for an affidavit, and also provide rules on alterations and striking of scandalous portions if it is deemed necessary. Chapter 15 is commercial causes, which we had already discussed, so I don't need to get into that again. Chapter 16 relate to administration suits. There's just one rule, Rule 237. Rule 237 requires a plaintiff to apply to the court for directions to classify the interest of the parties in an administrative suit and the interest of the parties in the property. And once the parties have filed their affidavit, the court may then determine the classes, and the court may also then determine that one class is to be represented by the same advocate. This is quite interesting. Chapter 17 is originating summons. This is also a very different concept. I haven't seen this used very often in the courts, but I think it is of a lot of relevance, and it can be used. I know Mr. Modi told me he's used it in one of his matters. Rule 238 to 261 is originating summons. The rules provide certain categories of people who may apply for originating summons. These include executors, administrators, trustees, legatees, heirs. They would generally apply for determination of certain questions that may affect their rights, either in relation to accounts or maybe directing them to abstain from doing certain acts. There may also be other persons who could apply, such as partners of a firm, mortgager, mortgagee, etc. All of those are detailed rules are set out in the chapter relating to originating summons. The procedure is also provided. a plaint is to be filed with the protonotary, but it does not include a prayer as we generally put. It just includes a relief. The documents do not have to be annexed except if they are documents that clarify the contents of the plaint. There is no obligation to file a written statement or an affidavit in reply. The judge may then ask for further documents or evidence and may give such directions that he may deem fit. Or then finally, the judge may either pass an order or dismiss the originating summons if he thinks it necessary, and then direct the parties to file a suit. And conversely, a suit may also be converted into originating summons if the judge deems it fit. This would be very relevant when the controversy between parties is not such that requires an entire suit with great disputed questions of fact, which require a lot of evidence to be led. And in such matters, it may be quicker and more efficient to just file an originating summons. Chapter 18 of the High Court rules provides for computation of time. And rules 262 to 266 are the relevant rules. I think rule 265 is definitely worth a mention because this provides the court with power to enlarge or abridge time as justice of the court of the case may require. So despite the timeline stated in the rules, the court may consider extending the time if it deems fit. And of course, the court may apply such terms and conditions as it deems fit. And chapter 49 of the High Court original rules, I was also asked to address you on. That finally deals with rules under the Power of Attorney Act, which essentially speak of these rules provide how the execution of powers of attorney is to be verified and how powers of attorney need to be deposited with the court. I think that's about it. I think I'm done. I don't have anything else to say unless there are any further questions or.
So we don't usually do questions here.
Okay.
This
And
is
it's been
just
a long session. Thank you for your time. A very long session, I realize.
I must acknowledge today we have some senior solicitors on our webinar. One is Mr. Priyas Jani. He was there, but he had to leave. He is our managing committee member, and he was there, and who's actually also instrumental in holding these webinars. We have Mr. Chaitanya Mehta from Dhruv Liladhar and Company today listening to our webinar, and we have Mr. Divya Shah, who has also been listening to you carefully. So thank you, Chaitanya Bhai and Divya Bhai, for being here.
Yes, thank you for attending.
Thank you so much, all of you. And now we'll be meeting on Saturday with the next session. Now CPC is over and we'll be moving into our next subject. Now we have execution in CPC left, which will be now on 8th of July, which will be done by Mr. Gaurang Mehta. Now we have got, I think, IBC code by Shivani. Yes, that is on Saturday. Shivani Khanna will be doing the IBC code. So please join in again. Thank you very much. Thanks, Vyom. It was a lovely lecture.
Thank you.
Thank
you for having me here.
You covered a lot of topics. Thank you so much.
Yes.
And thank you again, everyone.
All right.
Bye.
Bye. Thank you. Thank you for attending. Bye.